Afternoon, ladies and gentlemen. Welcome to this lecture. My name is Rainer Victor. I'm a European and German patent attorney in the law firm Vosses & Partner in Munich, in Germany. And I'm happy to have the honor today to introduce to you some recent developments of the unitary patent and the unitary patent court system that will soon start in Europe, and tell you some details about strategic decisions you might have to make in the next couple of weeks. Before we start with the details, I would like to refresh your memory a little bit, and let's look at the situation of patents in Europe today and tomorrow. At the first slide, you see a map of Europe, and you see the coverage of current European patent if it is granted by the European Patent Office. We have in red color the EPC contracting states, and then in addition in purple color the potential extension or validation states, and you can see even countries in Africa can be covered by a current European patent. When we now look at the next slides, we have now highlighted in light blue color the member states of the European Union, and you already can see here that there is no full overlap. The most prominent countries that are not in the European Union are Switzerland and the United Kingdom. And last but not least, on the next slide, you see the overlap of the so-called participating member states of the future system of getting a unitary patent or participating in the unitary patent court system. At the moment, there are 17 so-called participating member states, 17 countries of the European Union that ratified the agreements regarding the unitary patent and the unitary patent court. And these are the countries here in dark blue color. You can see some important European countries like Spain or Poland or maybe Ireland are member states of the European Union, but not, or at least not yet, participating states in the new system. Now let's have a look a bit more in detail what the new system will bring along. We have here on the next slide an illustration of the new court system during the so-called transitional period. The transitional period will start on June 1st this year, when the new system enters into force, and will then be a period of 7 years, during which there is a kind of a situation where unitary patents exist in addition to the classical European patents. So the slide shows the existing situation in the first line. With national patents, you have a bundle of national patents in Germany, UK, Italy, wherever. And for these patents, if you want to litigate them and enforce them, you go to national courts. In addition, with the new system, in the lowermost row, we have the unitary patent. And for those unitary patents, patent litigation and also revocation proceedings will take place before the new developed unified patent court. And then you see in the middle the situation for existing European patents and also future European patents during the transitional period, where you actually have two options. You have two options if you stay in the system. You can use the unified patent court for litigation proceedings in the future, but you can also still, in the classical way, litigate patents before the national courts. So that's a very flexible part of the new system during this transitional period. Another option that we illustrate here on the next slide is the so-called opt-out. You certainly have heard about the opt-out opportunity, and we will address that in more detail in the next few minutes. So if there is an existing European patent already issued, or a European patent to be granted after June 1st if the patentee decides that it is not desired to participate in the unified patent court system. An opt-out declaration has to be filed with the court, and I will also show later on today how that looks like. An opt-out declaration has to be filed informing the court, and this will be published in a register, that this patent stays in the classical system and can only be litigated before national courts. Well, and last but not least, let's already have a look on the system after the transitional period. We still have the national patents to be litigated before national courts. We will still have existing European patents after the transitional period, and then the unitary patents. And for existing European patents and for unitary patents after the transitional period, litigation is only possible before the unified patent court for these countries that participate. For the non-member states, non-EU member states like UK or Switzerland, again, the national courts are in charge of patent litigation proceedings also after the transitional period. For those countries, nothing will change, of course. So the question is, or a decision for you is, shall I apply for a unitary patent? Unitary patent, yes or no? And we have illustrated here, first of all, the time period during examination proceedings where you have a pending European patent application. And after grant, if you do not opt for a unitary patent, you have the validations in the individual countries where protection is decided as before. Or if the applicant wants to make use of the coverage with a unitary patent, a request for a unitary patent is made at the European Patent Office. And so you have, after grant, a unitary patent covering a number of countries. That's illustrated here with a big grayish circle, including a couple of colored smaller circles. These are the countries covered by the unitary patent. And in addition, you will still have national validations for those countries that do not participate or are not member states of the European Union. For example, Spain is a member state of the European Union, but not a member of the new system. So let's assume the smaller red circle is Spain, where you still would have to validate nationally. And the little circle in orange color might be the UK or Switzerland, where you still would have to have a validation in addition to the unitary patent. Now, I said a unitary patent has to be applied for at the European Patent Office after grant. And we show here on this slide that the term for this request is 1 month. So already 1 month after grant, a request form has to be submitted to the European Patent Office, and very important, together with a full translation, together with a complete translation of the entire patent specification. This is a pretty short time period. As you know, for the classical validations, there is a period of 3 months. So, for example, for a validation in Spain, you would have 3 months for preparing the Spanish translation and for validating the patent, the European patent in Spain. For the unitary patent, it's only 1 month. This is specifically important for the preparation of the full translation. This should be started early enough so that nobody runs into a hurry at the end. As you also see on the slide, this starts on June 1st this year. And until then, until June 1st, it would already be possible to request a stay of the patent grant at the European Patent Office. This can be done prior to filing a response to the communication under Rule 71.3 EPC. You might call that the notice of allowance, or together with the response. But at the latest, this has to be filed together with the response to the notice of allowance. So if you have a pending case where you already have the notice of allowance and where there is a deadline running for filing a response before June 1st, and if you are interested in getting a unitary patent for that specific EP patent application, you could request a delay of the grant until after June 1st when filing a response to the communication under Rule 71.3. So the European Patent Office offers here a very nice tool or a very nice opportunity, allowing patent applicants to make use of the new system, even if the patent grant would actually be expected too early. I just mentioned that decisions have to be made whether or not it is desirable to apply for a unitary patent after the EP patent grant. And one important factor for that strategic decision is certainly costs. What costs are involved when I apply for a unitary patent in comparison to the classical validations for a certain set of countries, for a certain territorial scope that is desired? And in the following few slides, we will compare a couple of different scenarios. So first of all, I have selected two pretty similar scenarios, a selection of 4 countries for the European patent, that is Germany, UK, and France as kind of standard set. And in the first example, scenario 1A, the Netherlands is also desired for the applicant. And in the alternative scenario, it will be Italy, who is also of interest for the specific applicant. And in the second exemplary case, the number of countries is a little bit enlarged. We have here a total number of 6 countries that are of interest to the applicant. Again, Germany, France, and the UK, but now here in addition, Italy and the Netherlands, and as an additional state, Spain. And you see here, I highlighted in green color those countries that are participating states, that are member states of the new system, and in red, the colors, in red color, those countries that do not participate or are not EU member states like the UK. So let's have a look at the costs in a bit more detail. I can tell you the big table here is a screenshot of an Excel calculation tool that we developed in our firm to assist our clients in making these decisions, where as an input data, the number of pages and words of a patent application can be input, and then a selection of countries can be made, and then all the data, translation costs, attorney costs, official fees are stored in that sheet, and an easy calculation and comparison can be made. And so for that presentation, I used that Excel tool, and you can see here in the left-hand column of the sheet, in the yellowish column, the selection of the 4 countries, Germany, France, United Kingdom, and the Netherlands. And then you have a list of potential attorney fees, official fees, the fees of the colleagues you would have to pay in the countries for validation. And so in the right-hand column, the greenish column, you could see the total costs in each country. So there are attorney costs involved, and for the Netherlands, also some translation costs because the claims have to be translated. So, and if you then sum up these 4 numbers in the green column on the right-hand side, you end up with a total amount of 1,969 euros, which would have to be paid for that specific patent application for national validations. Now let's compare that with having a unitary patent for Germany, France, and the Netherlands, and in addition, still the national validation for Great Britain, for the United Kingdom. So we assume that the validation costs for Great Britain are 525 euros. That's a reasonable amount for attorney costs involved for the validation. And the costs for the unitary patent in this example are 2,176 euros. Now, how is this number calculated? It's basically the translation costs that you need for the unitary patent. In this example, for an average application with 10,000 words, about 10,000 words, the translation costs are roughly 2,000 euros. And in addition, there might be an attorney fee charged from your law firm for filing the request for unitary patent. And so it's a bit more than 2,000 euros for the unitary patent. I can say that the translation costs in this and also in the subsequent examples is based on the costs for Spanish translation, because we have learned that Spanish colleagues are at the moment offering full translations at a very low price. So by using a Spanish translation, a very low price unitary patent request can be filed. I should also like to mention that, of course, if you apply for a unitary patent, you get additional coverage in other countries, and the countries are also listed here in the box on the left-hand side. So the costs, the validation costs for the route with a unitary patent are definitely higher compared to the classical validations. However, there is not only the validation costs, we also have to consider the annuities. And let's assume we look at a European patent that is maintained in these 4 countries until the very end of its lifetime, so for 20 years. And so we have here a diagram showing the cost for each year, the costs in year 5. So we assume the patent is granted in year 5 are the highest, because these are the validation costs. And you see the green part is higher than the reddish one because the UP costs are higher. And then the subsequent costs are the annuities, which increase year by year. You can see for this example, actually the annuity fees are not too much different when we compare the sum of the annuity fees in the 4 countries with the annuity fees for the unitary patent and in the UK. Only then in the end at year 18, 19, 20 in this area, the annuity fees for unitary patent become larger compared to national annuities. If we now compare that in an accumulated way, so the costs are added up year by year, you also see there is not a real big difference. The unitary patent is always a little bit more expensive, but not much. So one can conclude that for this example, and assuming that the patent will be maintained for 20 years, it doesn't make a difference whether you choose the classical validation route or the unitary patent route. Of course, as I said, the unitary patent route would have the advantage of coverage in additional countries, the additional participating member states. For the same example, we have here a little variation. So for the UK and Netherlands, the patent will be dropped after 15 years. So this might be a potential strategy for the patentee, already knowing that the markets are maybe not so relevant in the UK and the Netherlands, and it is planned that the patent is dropped after 15 years. Then you see here in the accumulated costs that the reddish part does not increase as steeply as before after year 15, and then the costs for the unitary patent become higher compared to the national costs. because you cannot drop Netherlands out of the unitary patent system. So the unitary patent annuity fees will remain the same. If you choose for unitary patent, you can only drop the UK as a separate country after 15 years. So for that example, maybe there's a little disadvantage for the strategy choosing a unitary patent and the UK in addition. I have now here a variation of that example, and I'm sorry that my head in the picture is somehow blocking the heading of that slide. In that example, France and Netherlands are dropped after 15 years. And in this example, the cost advantage of national validations is even higher, because again, for the unitary patent, you cannot drop individual countries from the annuities. The payment of the annuities would continue even if no interest in France and Netherlands is there for the last 5 years. Now let's move to the alternative scenario 1B, where we have intended coverage for Germany, France, UK, and Italy. And here you see now already a big difference to the previous example. But maybe let's first look at the Excel sheet here. In the yellowish line, you see we have chosen Germany, France, United Kingdom, and Italy. But if you now look at the line, the orange colored line for Italy, you see that there are translation costs for the claims and the description. And so we have total costs in Italy of 2,747 euros. And so the total costs for national validations in this example are more than 4,000 euros, 4,059 euros, as you can see at the top left box on this slide. And if we compare that with the alternative approach of applying for a unitary patent and have the national UK validation in addition, again, the costs are the same as in the previous example, only about 2,700 euros, with the benefit of additional coverage in the other participating member states. And so in this example, it might really be a consideration whether or not to apply for a unitary patent. And so let's again look at diagrams relating to the costs. Here we have, first of all, again, the annual costs for the assumption that the patent is maintained in all states for 20 years. We have the very high validation costs in year 5 in this example. Due to the higher translation costs, the translation costs in Italy, the validation costs for the classical validations are substantially higher. And then in years 6 to 20, we have the annuity fees. In this example, the annuity fees in Italy are lower than in the Netherlands, which we had in the previous example. And so here you see clearly a difference between the annuity fees that are due for a unitary patent plus UK, that's the greenish diagram part, or for the national validations in Germany, France, UK, and Italy. If you look at the accumulated costs, due to the high validation costs at the beginning, for the first couple of years, the accumulated costs for the national validations are higher, but they are about the same already in year 14. And after year 14, then the accumulated costs for the national validations are lower. And so in this example, it also plays a role to consider how much countries are maintained, how much validations are maintained in each country. And so we again look here at an example where France and Italy are dropped after 15 years. First, we look at the annual costs. Again, we have the very high initial validation costs and then the annuities each year. And because France and Italy are dropped, the national annuity fees then get substantially smaller for years 16 to 20. But for unitary patent approach, it would not make a difference. You would have to continue pay all the annuities for the unitary patent, even if France and Italy are no longer desired. And if we look at the cumulated costs again for this example, with France and Italy dropped after 15 years, also here the break-even point is between years 14 and 15. So the conclusion is, if it's anyway not desired to maintain the patent for 20 years, in this example, the unitary patent approach would be cheaper if the maximum lifetime would be 14 years or even shorter. The third example here, scenario number 2, has a larger coverage. We have selected Germany, Spain, France, UK, Italy, and the Netherlands. Again, in the green color at the right-hand side, you see the total costs for a national validation in each country. For this example, with the 6 states, the national validation costs are again higher. It's now more than 6,700 euros. And if we compare that with the unitary patent approach, here now with Spain and UK in addition, the total costs are 2,725 euros. We have the additional validation costs in the UK, and we have the translation costs in Spain. However, the translation costs in Spain do not really add up anything to the unitary patent because it can be used for the validation and for the request to get a unitary patent. So the translation, the Spanish translation, can be used for 2 purposes. First of all, for the national validation in the country and for getting the unitary patent. And so here the cost advantage in such an example of the unitary patent, at least for the validation, is pretty evident. And if you again look at diagrams, you see here the very high validation costs because of the translation costs in Spain and Italy. And you see also the costs for each year. The annuities are higher for national validations because you now have to pay 6 individual annuities each year, compared to the single unitary patent annuity and Spain and the UK in the alternative strategy. The cumulated costs are also very illustrative. Clearly, the accumulated costs for the unitary patent approach, which with Spain and UK in addition, are substantially lower throughout the whole lifetime of the patent. Now let's again look at a variation of this example where Spain, France, and the UK are dropped after 12 years, and Italy and the Netherlands are dropped after 15 years. Here for the annual costs, you see that the annuities go down in both examples, because in both alternatives, with or without unitary patent, the annuities for UK disappear after 12 years, and for Spain, but the annuity dropping of France, Italy, and the Netherlands does not have an effect at the unitary patent approach, as I explained. And when we now look at the accumulated costs, still the unitary patent is more cost efficient for a very long time of maintenance of the patent. I highlighted it here with this vertical line. Only after year 18, the unitary patent would get more expensive in this example if it is maintained until the end of 20 years, and if also Germany is maintained until 20 years. So what are the conclusions on costs if we look at these examples? First of all, if only Germany and France is of interest, it's actually an example which I have not shown here with diagrams, but if only these two countries are desired, but no other UPC member states, then the classical bundle pattern with national validations is certainly more cost effective because no translations are required, only annuities in these two countries. If there's interest in at least 4 UPC states, which is the scenario number 2, then already the unitary patent can be more cost effective. If there's interest in any of the UPC states, Austria, Bulgaria, Estonia, Italy, or Portugal, then the unitary patent can be more cost effective. We then would have to keep in mind that for Austria, a German translation is required. So, unless the patent is in German, so a German translation is required, and the German translation costs would be a little bit higher than the Spanish translation costs that I mentioned. If interest in Spain is desired, which is not a UPC state, then the national validation there requires a complete Spanish translation, which can be used for the unitary patent. So also in this example, choosing a unitary patent can be more cost effective. So we have now looked at different scenarios about costs, which might help you to make your strategic decisions whether or not to apply for a unitary patent. And I would now like to switch to other strategic considerations and recommendations for you. So during the examination proceedings before the EPO, there is not much you can do because the request for a unitary patent or for unitary effect can only be made after grant. But then there might be a couple of alternatives you should consider. So in addition to the unitary patent, consider EP patents that are not opted out, or EP patents opted out or opted out and in again. And also consider national patents still, or even utility models like German utility models. Now, why am I mentioning this? The reason for that is that the request for a unitary patent and the national validation in the UPC states is mutually exclusive. So that means that it is not possible to have a unitary patent and a European patent in UPC states based on the same application. But you could have a unitary patent and a European patent with classical validations based on a division application, for example. So you could choose to apply for a unitary patent for the parent application and have a divisional EP patent application granted and do national validations for the divisional, or the other way around. First the national validations and for the divisional, the unitary patent. At the EPO, there is the provision of double patenting for the same subject matter, which means that sometimes trivial claim limitations are required in the claims, or maybe different terminology or different categories, product and method, to have a kind of double protection for a parent application and a divisional application. And this may also apply for European patents that stay in the system and European patents that are opted out. So, for example, you have an existing EP patent that you leave in the system and an existing divisional EP patent that you opt out. So if you considered to supplement unitary patent protection with a divisional EP patent, this offers, of course, much flexibility, but is costly because you have to pay the annuities at the EPO for 2 applications and then the annuities later on for the EP patent and the unitary patent. So an interesting alternative could be to consider a unitary patent and in addition a national patent to have a double protection. For example, if we consider Germany does allow double protection for a unitary patent and in addition a national patent in Germany, or for a European patent and a national German patent. This actually was a change in the system. Before, the UPC system entered into force, or will enter into force, such kind of double protection between EP and German was not possible. With a short limitation, if there's an opt-out of the EP patent, then we are in the same regime as before. Then there's no double protection. Now, how could that work? You could consider a PCT application where you enter the European regional phase to obtain an EP patent and maybe later a unitary patent. And you could at the same time enter the German national phase for this PCT application. This would require a German translation. And so you would have some additional costs at that stage in the proceedings. But this German translation for the German national phase can be used later on as the complete translation for the unitary patent. So you would save costs later on when the request for the unitary patent is made. And in order to minimize costs for these parallel German applications, you can make use of the deferred examination that is available in Germany. It's 7 years from filing. And it's also possible to reduce costs during prosecution to request long-term extensions. So if you receive an office action for a German application and you have a parallel EP patent application, you could request an extension of a year, for example, and you can do that multiple times. The German Patent Office will not object to that. And such kind of double protection is also available in other countries that we have listed here. And there are some advantages and disadvantages. The advantage over the previous example with a division application is that it is less costly and you would have probably less issues with claim amendments at the German Patent Office because the added matter issue is not taken so serious there. The downside is for this approach, as I said, you have some higher costs at an earlier stage for the German translation. A still cheaper alternative, especially in Germany, is to apply for a German utility model in addition to a unitary patent. You can do that either out of a PCT application, again with a national phase application, or what is a very interesting tool in Germany, you can derive a German utility model from a pending EP patent application at any time up to grant. Also for the German utility model, a German translation would be required, but again, it can be used for the unitary patent translation later on. And let's consider you create such a utility model after you receive your notice of allowance of the EP patent. Then you generate translation costs at a time in the proceedings where you would need the translation anyway for the request for the unitary patent. And so for such a scenario, the procedural advice would be to derive a utility model just before the EP grant. So this would be the cheapest way to get an additional IP right, to get additional double protection in addition to the unitary patent. You have no issues with amendments. The only downside here is that the maximum lifetime of a German utility model is only 10 years. Further strategic decisions relate to EP patents. I mentioned that at the beginning, that are about to be granted. So if you want to make use of the unitary patent after June 1st, but the EP patent will be granted too soon, you can first of all make some minor amendments in the text of the patent application that is held allowable. This will be an amendment in response to the Rule 71.3 communication and will trigger the issuance of another communication under this rule, another notice of allowance. And so the grant will be delayed by 4 months. which, as we are already now in April, will certainly help you to get beyond the June 1st date. Other alternatives, I also mentioned, that is to request a delay for issuing the grant in response to the notice of allowance communication, or it would also be possible to file a request, an early request for a unitary patent at the EPO already at this stage, which will then be effective on June 1st. So the conclusion, what points are to be considered? So depending on the countries, a unitary patent can significantly save validation and renewal fees, but you have no flexibility with respect to enforcement or invalidation. It has to be litigated before the UPC and can only be enforced or revoked in one shot. During the transitional period of at least 7 years, maybe 14 years, traditional EP patents will be the most flexible, at least in terms of costs, but also in terms of litigation. You can do forum shopping. So decide in particular whether opt-out is desired for cases pending in litigation, opposition, or for patents that are likely to be litigated or opposed. Because when you apply for such an opt-out, then the patent in litigation or in opposition will be taken out of the unitary patent court system and route. Keep in mind, a granted patent cannot be transformed into a unitary patent once the new system starts. Therefore, as I mentioned, consider the delay of the grant. And as I mentioned, consider national applications as a safety net. Double protection will be possible, for example, in Germany. And the translation or a translation needs to be prepared anyway for the unitary patent. So this could be the German translation. Yeah, I mentioned the opt-out frequently, and here is a list of potential considerations for you when an opt-out might make sense or not. It might depend on the business unit. If the business unit is a core business unit, then maybe opting out might make sense for the case that the UPC does not develop as planned. For potential future business units, you could stay in the system just to make use of the lower costs. For important products, again, an opt-out might be considered if the system does not develop as planned. However, I could mention at this stage, we have seen a couple of weeks ago which judges were appointed for the local divisions and for the central division. And from our experience, we know many of these judges as being specifically patentee friendly. So from that perspective, we believe that at least at the beginning of the UPC system, there will be a pretty patentee friendly approach taken in litigation, in infringement proceedings, but also in central revocation proceedings. So we do not expect that the central division being in charge of revocation proceedings or local divisions dealing with a counterclaim for revocation will be very restrictive and will be revoking the patents. This would undermine the whole system if the system or if the judges would be not patentee friendly. So let's get back to our list here and to our bullet points. Unitary patents might be interested for low-cost products. If a divisional application is pending, the bifurcated approach could be chosen, UP for one and EP for the other. If the patent is essential for standards, it might make sense to use the system because a validation risk is low. If no enforcement is planned, no reason to opt out. If you have an existing huge portfolio, then of course the opt-out might cause you some headache these days because it's a huge effort to opt out. It takes some of your budget. Registers have to be updated regarding true owners. This is something to consider. If a patent survived an EPO opposition, there is less risk of central revocation. It might be a really strong patent already. And if oppositions are pending, then keep in mind an opponent could initiate parallel central nullity actions, and so an opt-out would be recommendable for such a case. Now, let's briefly look finally at the case management system and how the opt-out practically works. This is the starting page if you want to enter the system. And I have just now on the next few slides an example opt-out request that I filed recently. So an opt-out request does, for example, look like this. It's an opt-out request, and then you have the European patent details. Here's the patent number. And then it's opt-out for all states in which the patent has been granted. And so the opt-out request just lists all states, here also Switzerland, although it's not a EU state, Germany and Spain. It lists the patent owner, the patent proprietor, because they could differ for the different countries. And so for each country, the patent proprietor is indicated in the opt-out request. Then further down, the details are given of the person who lodges the opt-out request. In this case, it was me. My name is here. I'm a representative. If you use maybe a service provider for opt-outs for your patents, then they would have to provide a mandate with the opt-out. And last but not least, you see here a digital signature for the opt-out. Then you will receive a confirmation for the opt-out, an acknowledgement. It gives the number of the application. So this specific example was 4,231 opt-out in 2023. You see the date of the opt-out, my name as the registered representative. Then there are the details of the patent that is opted out, the patent number and the title and the patent proprietor. If you have a pharma patent, there might be some SPC details of the supplementary protection certificate. And then declarations are included that I am as a representative are really entitled to do the opt-out for that patent. And then there is the information about the document, the opt-out document that is uploaded. So that is how it practically looks like in real life. And we are already started filing opt-out requests for our clients. So, and this concludes my presentation of today. I would like to thank you very much for your attention. And after this presentation has been terminated, I'm happy to take your questions and to provide information on detailed issues or problems you might have. Thanks very much again.